And my name is Michael Zuboff, and we're both entertainment lawyers at Edwards Creative Law. Our head office is in Ottawa. However, we kind of have lawyers a bit spread out around the province now. I'm located in Toronto, and Ian is in Kingston. And we're excited to be talking to everyone today about copyright law, publishing, and option agreements, and other kind of related topics that might be relevant to you as poets and other writers. And we want to keep this a bit more informal, so if anyone has any questions, feel free to drop the question into the chat. We'll try to keep an eye on it as we go along, and if not, we'll open it up kind of after we're finished our slides and our discussion to any remaining questions that anyone might have. Ian, did you want to say anything about our practice or the firm or anything before we jump into the meat?
Well, I think you covered it pretty well. We do entertainment law, which means that we typically, which is really more descriptive of who our clients are, which are people who work in the entertainment industry. So we work with a lot of television and film producers, as well as book publishers. Actually, we typically work for writers in negotiating book publishing agreements. And we work with musicians, and to some extent, we also work with developers of what's called interactive digital media, video games. But the kind of general description of our practice is we work for people who create art, be it music, film, television, books, and poetry certainly falls within that ambit. And a lot of the stuff that we practice is applicable to poets. If you are encountering a situation where you need legal advice. So I'd just like to start with an overview of the presentation. We're going to start off by talking about a very high level kind of understanding of what copyright law is and when copyright exists, what you need to do to get copyright, and what copyright entitles a person to do. And we're going to talk about fair dealing, which is a common exception to the rules of copyright. Fair dealing is a situation where you can use a work that would otherwise be considered copyright, but the use in that particular instance wouldn't be an infringement of copyright because it's fair. And we're going to cover some of the basics of contract law. What forms a binding legal agreement? What are the common and fundamental terms that you would expect to see in a contract? And then we're going to get into some specific contracts. And today we're going to talk about publishing agreements. So if you are engaged by a publisher who wants to publish and distribute your work, and an option agreement, which is an agreement that you would enter into as a writer or a poet with somebody who wants to acquire the rights in your work to typically make a movie or a TV show. Next slide, please.
Ian, do you mind plugging your mic in and out quickly? For some reason, it's getting a little static. I'm not sure why, but
maybe I should just do this. Is that audio fine?
It's still getting a little static. I'm not sure why. We can still hear you just fine, but
okay, I'll try plugging in.
That's whatever you just did there. It's better. We're good.
Well, I was kind of in the middle of doing something there.
So. Okay, it's perfect now.
Perfect now?
Yeah.
Okay.
Okay. Yeah. So moving on, in general, too, just to kind of add to Ian's points. Questions that we sometimes get are just what exactly do we do, and what is our role with our clients, and especially as entertainment lawyers, sometimes it's a bit vague how we help our clients. So often we'll kind of just facilitate kind of the projects they're working on. We help them to kind of move projects along. Sometimes if the client receives an agreement of some kind, we'll help them to understand the terms of it. In some cases, we'll help to negotiate or kind of just create a dialogue to to improve the terms if we have concerns about them. But generally speaking, we're there to help protect the interests and rights of our clients and help them to get their projects made. So moving to Copyright 101. Again, copyright is a phrase that's thrown out there often in the arts, and there's instances where people don't understand the full extent of what copyright is or how it helps individuals, and as well as how to acquire copyright. So copyright really is it's a bundle of rights that are set out in the Copyright Act. So it's a federal act that is accessible to anyone. You can just Google it on the internet, and it's fairly in-depth. So again, this is something that we can help you to understand if you have any questions about it, but hopefully today we'll give a brief summary of some of the important aspects of the Copyright Act and copyright in general. So it's a bundle of rights that gives the owner of a work the sole right to produce, reproduce, perform, and publish a work. So that would be the work or any substantial part of the work in any material form. It similarly is the right to prevent others from doing anything that the owner has the sole right to do. So if the owner has the sole right to do one of these things, such as reproduce the work, which someone else copies, if they also try to reproduce the work, that would constitute a copyright infringement. The first owner of the copyright is the owner, the author, or the creator of the work. We'll get a bit more in just a few slides into what constitutes this in a bit more depth, but the copyright owner at the first stage is the author or creator of the work. There is kind of an exception to this though, and that's where the work is created by an employee during the course of employment. So if you're working for an employer and you're still a creator of some kind, the work that you create will actually, the ownership will transfer to the employer, or it'll vest in them. Again, the rights that a copyright owner has, they're to produce, reproduce, publish, perform, and so on. And there are a few exceptions to this, and as mentioned earlier by Ian, one of the primary ones is the exception of fair dealing, which is found in the Copyright Act, and we're going to be discussing this in a bit more depth shortly, as well as a public reading or recitation of a reasonable extract of a work. That's again found in the Copyright Act, and it is one of the exceptions to the copyright protection. And then there's some other more abstract ones that we're not going to focus on here, but if you do have any questions about any of these exceptions that I'm able to list off, again, feel free to reach out to us and we're happy to discuss. There's items such as non-commercial user-generated content. There's reproduction for private purposes. There's backup copies of works. Certain educational institutions have limited rights to use copyrighted works, as well as libraries, archives, and museums. So these are the exceptions to the general mandate of copyright.
We have one question in the chat here. We have a question asking, copyright doesn't apply to the IT field, such as a programmer's code?
Right.
Yes, it can apply to code as well.
We're going to address later specifically what counts, what is copyrightable. It is kind of a blurry line. It involves a subjective interpretation. But computer code has certainly been found to be copyrighted.
Thank you.
And I just would like to clarify a point about works made during the course of employment. If you are an employee and you make creative work as part of your duties as an employee, then the employer is the first owner of copyright. However, you are free to make creative works outside of your duties as an employee, and your employer would not be the owner of copyright in that situation. So it's only works that are made during the course of your performance of your duties as an employee.
Yeah, that's a good clarification.
Next slide, please. Okay, I'm going to talk about copyright registration. So, as you may be aware, you are able to register copyright in your work. And this is done by going onto the website of the Canadian Intellectual Property Office and filling out their registration form. Now, do you need to register your work to have copyright? The answer is you do not. Copyright vests automatically upon creation. And when is it created? It is when an idea is expressed in a fixed form. So, for example, I have an idea for a poem that exists in my head. Copyright does not exist at this point. As soon as I write that poem down on paper, copyright automatically and instantly vests within me, and no registration is required. So why then would I bother registering my copyright? Well, copyright registration creates what we call a rebuttable presumption in your favor. So if you are the registrant of copyright, it is presumed that you are the copyright owner until somebody else proves otherwise. On the other hand, if you are a copyright owner who is not registered and some third party claims that they are the owner, the onus is on you to prove that you are the true owner. So what the copyright registration does is it shifts the burden of proof. It takes the burden of proof away from you if there's a dispute, who would have the onus of proving that you are the copyright owner, and it shifts it to the other party to prove that you are not the copyright owner. And that can be very advantageous in the case of a dispute. And it's relatively inexpensive, as we put here. It costs $50 for a copyright registration and $65 for the registration of an assignment or license. I think it's also interesting to note that when you register your copyright, you're not required to provide copies of the copyrighted material. The copyright, the Canadian Intellectual Property Office will just take your word for it. And that's an important distinction between the United States Copyright Office, which will in fact require you to submit copies of the work that you are registering for copyright.
So one question I know I've gotten in the past, Ian, is when should you register? If you're going to register, when would be best to do so? Any thoughts on that? Because I know that some people in the past, if you're writing, for example, a screenplay or whatever work, there's multiple drafts of it. And so people sometimes ask whether you should be, registering each version of it, or if you should wait till it's in the final form. Do you have any
I don't see a
on that?
real advantage in delaying registration. Get it in there as soon as you can, because then you've got the rebuttable presumption in your favor from that point. I also don't think it's necessary to register every iteration. If you have the copyright registration in the first iteration, you're not going to have a hard time proving that you also own the copyright in the 10th one. So yeah, I don't think there's a huge advantage to registering every version or to delaying your registration until the work is complete.
And there's a question here. If you are published often, can copyright vest in your name?
I need a little clarification on what that question means. Do you mean, is there actually copyright in the printing of your name, or are you the owner of the copyright of the text that's being published? Sorry, if we could get a clarification on that question and then answer it. Yeah, once we have that. And I think we can move on to the next slide.
Sure. Yeah, and the next slide might actually respond to that. Yes. So the message is yes on anything under your name. So again, copyright will come into existence on its own. This slide here will discuss that a bit. So as Ian mentioned, copyright protects fixed expressions of ideas in a material form. So what that really means is the idea needs to be translated and recorded in some way in order for the copyright to be created. And again, there's nothing that needs to be done in addition to that for the copyright to come into existence. So for example, if you're a musician and you've come up with a song, it's once, for example, you might write down the notes to the song, or you might record the song in its entirety. And once that's done, the copyright will exist. Similarly, if you're a poet and you have a poem in mind, and you have the entire poem plotted out, but it's only in your head, the copyright does not yet exist until you've actually recorded it in a material form. So it could be typing it out on your computer, be writing it out on a napkin. Once you've done that, the copyright does exist, and it exists under your name. So one of the key points of copyright is originality. It's the foundation stone of copyright. Originality must be present in order for a work to be protected by copyright. However, novelty and inventiveness are not the test of originality in the law of copyright. The test is whether a work is original in the sense that it is the original expression of thought of its author, which originated from the author and was not copied from some other work. So it can't be a copy of another work, it must be original to the author, and it must be a product of the author's exercise of skill and judgment. And a lot of these cases come down to what exactly is meant by skill and judgment. So how it's characterized is not as a purely mechanical exercise. And again, that can be difficult to ascertain, and there's a lot of case law about this, but this is the general framework for the creation of copyright. Similarly, if there are sufficient similarities between one work and a preceding original work, then substantial copying will likely be established. However, again, it comes down to a case-by-case basis for that. So as mentioned, for something like a poem, it's not protected until it's expressed in a fixed medium, which may be recording it down or, writing it down or recording it through audio. If that idea itself is copied, but not the tangible asset, then it will not be copyright infringement. So again, it's that differentiation between the idea and then how it's actually been recorded or fixed to a medium.
And I think at this point, I could raise an interesting example that Michael and I had recently. And it is interesting in the context of the requirement that copyright does not vest in a purely mechanical exercise. So we had someone come to us that wanted to use an old film that was in the public domain. However, the only copy of the film that this person could get was a digitally remastered copy, which had been digitally remastered recently. And the question does copyright exist in the digitally remastered version such that this person wouldn't be able to use it because without the permission of the party who had done the digital remastering? And we found that merely putting the old film into a computer program which digitized it would not attract copyright because it was a purely mechanical exercise. However, in this case, there were artists that touched up colors, that paid a lot of attention and put a lot of effort and skill and judgment into creating the touched up modern digitized version of the film. And we found that there was likely that copyright would exist in this recent release of what was previously a public domain film, but that the person could, if she obtained a copy of the old film, use that.
Yeah, it's an interesting point about emerging technologies and how that kind of affects the tests of originality and using works that are in the public domain, of which that specific point we'll be talking about in just a moment. And so I just wanted to add as well to this slide, just kind of listing off some of the types of works that are copyrightable, because it is quite extensive. And It may be surprising just how far copyright can extend. So copyrightable works includes literary works, it's books, pamphlets, computer programs and codes, and other works consisting of text. It covers dramatic works such as motion picture films, plays, screenplays, and scripts. It covers musical works such as compositions with or without words. It covers artistic works such as paintings, drawings, maps, photographs, sculptures, and plans. And it even also applies to performers' performances, assuming that they are recorded. So this is performances, recitations, or improvisations. So again, it covers all of these things so long as they've been fixed in a material form. So now we're going to go into the life of copyright.
So how long does copyright last? Not forever. Copyright expires after a certain amount of time, and that time varies by jurisdiction. And after copyright is expired, the work goes into what's called the public domain and is usable by anyone without liability for copyright infringement. So in Canada, as of yesterday, the life of copyright is for the full lifetime of the author plus 70 years from the end of the year and the year which the author died. Up until yesterday, it was life of the author plus 50 years, but that was changed. A new law received royal assent yesterday, and it was increased to 70 years. So now it's the same as the United States and most other international jurisdictions with which Canada does a lot of business. So we were really just coming into line with our major trading partners and making that adjustment. So any work that was due to enter the public domain at the end of 2022 will not be doing so. It will now have a further 20 years of copyright protection. However, anything that fell into the public domain at the end of 2021, which was the last time that works entered the public domain, will remain in the public domain. So basically in Canada right now, nothing's coming into the public domain for 20 years, is the fallout of that. An important thing about the life of copyright is it's tied to the life of the copyright author, who is the person who created the work, the individual who created the work. It's not tied to the life of the copyright owner. So, for example, if you're an employee, you create a work of copyright during the course of your employment. Your employer is the owner of the copyright, but you are the author, and the life of the copyright is tied to your life. It has nothing to do with the owner. This is a distinction from what exists in the United States. In the United States, where an employee creates a work during the course of their employment, or if you're not an employee but an independent contractor and you create a work that is a work made for hire, which may be a phrase you've heard, then your employer or the person commissioning the work from you is not only the copyright owner, but they are considered the author of the work for determining the lifetime of copyright. Now, sometimes that is not an individual, but a corporation, and corporations don't die. So when the author of the copyright is a corporation, there's a different test, and this is only applicable in the United States and probably not applicable to anybody here, but basically the law in the US is where a corporation is the copyright holder. The life of copyright is 95 years from the date of first publication, or 120 years from the date of creation, whichever is the shorter of the two. And I guess we've got the example down at the bottom here. Shakespeare's works, which were published in the 1500s, have all been in the public domain for many hundreds of years. So yeah, older things are in the public domain, and it's a long time. from the creation of a work until it enters the public domain. You know, if I create a work and I'm 20 and I live till I'm 80, that's 60 years, and then you add 70 years on top of that, so it's 130 years. That's a long time. Next,
Yeah.
please.
And just like to be clear, things that are in the public domain, again, the point is that there's no copyright over that work, and so people can do whatever they like with it. So people can make their own versions of Shakespeare's stories. They can turn it into a film, a theater production. They can remix it and do whatever they want because it's in the public domain. And for poetry specifically, obviously there's a lot of famous poems from way back in the day, many of which the authors aren't even known at this point. And these are all in the public domain now. And so people can be free to do what they want with these poems and, again, adapt them in any way they want, to add to them, illustrate them. And so these are kinds of just the ability of what you can do with works in the public domain. So fair dealing. So we had mentioned a little while back that fair dealing is one of the primary exceptions to copyright. It's found in section 29 of the Copyright Act. And in essence, what it is that it allows people to use copyrighted works subject to the stipulations in this act, which is a two-step analysis that, one, the work must fall within one of the categories identified in the Copyright Act, or use of the work must fall into one of the categories. And two, the use or the dealing of the work must be fair. And there's a similar concept in the US, and it's called fair use. And there are similarities between the two concepts, but there are also important distinctions. So if you're relying on kind of literature or text about fair use, just make sure that you kind of compare that to how the concept of fair dealing in Canada. And so the categories of fair dealing are research, private study and education, parody and satire, and criticism, review, and news reporting. And so when you're dealing with fair dealing and when you're assessing a use of a copyrighted work, the following factors can be considered in assessing whether a dealing was in fact fair. So the items are things such as the purpose of the dealing, the character of the dealing, the amount of the dealing, so how much of the work was used, alternatives to the dealing, so were there alternatives present in exchange or besides using the work, the copyrighted work as has been done, also the nature of the work and the effect of the dealing on the work. So although these considerations will not all arise in every case of fair dealing, this is a list of factors that provides a useful analytical framework to govern fairness in future cases. So there are a lot of these items, you can kind of apply them to items that people hear about all the time. So a review and criticism and news reporting that often will kind of relate to journalism or simply put news reporting. There's parody and satire. So, you know, there's media out there or programs such as, I'm sure people have all heard of South Park, where, you know, they're sued quite often for using copyrighted works, and they've often put forth the defense of parody or satire. And then there's kind of artists or musicians like Weird Al, although I think Ian has a point about the fact that he actually licensed the use of the songs that he parodies and doesn't actually rely on the fair dealing or fair use defense, although he probably could if he wanted to.
Well, I think the point is that Weird Al's work probably wouldn't qualify as a parody, because a parody is not just, you know, it's not just something that's based on and looks similar to the work which it's which it's parodying, but it needs to contain some kind of critical element. It needs to provide some kind of commentary on the work which it's parodying. And that's why, and I did this analysis recently. Weird Al's work wouldn't actually qualify as a parody for the purpose of fair use or fair dealing.
Yeah, And what's interesting too in Canada is that it was only in 2012 that the categories of fair dealing were extended to items such as parody and satire. So prior to 2012, it was actually still contentious and it wasn't enshrined in legislation, this exception.
And I just want to repeat here, I know we've got it written on the slide, so it's obvious. It's a two-step test. First, does the work fall within one of the enumerated categories? Is it research, private study, education? Once you've established that, which is the easy part, then you need to do the analysis of whether the dealing is in fact fair. And that is a complicated, highly fact-based analysis. Michael read about 6 factors that the court will consider. It is not an analysis which is easily undertaken. So if you intend to rely on the fair dealing exception under the Copyright Act, you need to be aware that it is a complex analysis, and it's not just that your work falls within the category that the Copyright Act says will qualify as fair dealing.
Yeah. Are there any questions out there on any of the copyright or fair dealing information we've discussed so far? In just a minute, we're going to be kind of transitioning more into contract law and types of agreements. So I just wanted to open up the floor for a moment and see if anyone has any questions about this content.
And I also want to go back to Lisa Reynolds. Did we sufficiently address your question?
Feel free to unmute yourself as well if you wanted to just ask us. Yeah. No?
Perfect.
Oh, here we go. Yes, it was addressed. All right.
All right, contract law basics. If you are offered by a publisher to publish your works, you will likely be asked to sign a contract. Now, if you're self-publishing your works, that's a different story. But if you are having a third-party publisher publish your works, they're going to present you with a contract, and it's good to know some of the fundamentals of contract law. So first and foremost, we're going to talk about what makes a legally enforceable contract. There are several basic elements that need to be in place. First, there needs to be a clear offer and acceptance. So somebody needs to offer you something. The publisher says, I offer to publish your book on these terms. And you say, yes, I accept your offer. There also needs to be what's called consideration, which means both parties need to receive something of value. So in the case of a publishing contract, both parties are likely to receive money or the potential receipt of money if the book is sold. If you are entering into a publishing contract, hopefully you'll receive an advance from the publisher, a monetary advance. That would be your consideration. You'll also receive royalty payments based on sales of the publication. And the publisher will receive the right to produce and disseminate the published work and to, of course, retain a certain portion of the sales themselves. So in that example, that's how both parties are receiving consideration or something of value. Oftentimes, contracts where people don't want to exchange anything of value include consideration of token amount, like $1. And we see that all the time. If I, for example, wanted to have a contract with a corporation that I own, and I didn't need the corporation to pay me anything, but I wanted to transfer some rights to the corporation, I would say the corporation pays me $1. And then that is all it takes to have for consideration to make a legally enforceable contract. Another element is called ad idem, or meeting of the minds. Ad idem is the Latin. And that basically says the parties have to agree on the terms of the contract. Now that is pretty easy to determine in the case of a written contract because the agreement of the parties is in writing, so there's no question. It's a more difficult thing to prove in the case of an oral contract. There needs to be certainty of the essential terms of the contract. If there is no certainty to the essential terms, such as who are the parties, what are you getting paid, what is being exchanged, then there's no binding contract. And finally, there needs to be an intention of both parties to be legally bound. Now, in the case of written contracts, these factors are typically not at issue, and they're more come into the analysis when there are verbal agreements and people are trying to prove the existence of a contract when there's nothing in paper. Then these points need to be scrutinized. There's many other factors which could result in an unenforceable contract. For example, you're signing the contract under duress. There's many of them. There's a whole first year law school class, which basically focuses on what makes an enforceable contract. But I've just talked about what the basic building blocks, the elements are, without kind of the unusual factors which may influence whether a contract is enforceable. Is it too late to put it in writing? Never. And it's always recommended to put it in writing, even if it's in an email. Having something in writing which you can go back to at a later date, could be years later, and say, what were we thinking at this time? Very helpful. So, it doesn't need to be a formal contract drafted by a lawyer, but it's always good to have a statement of the parties' understanding in writing. It's never too late to do so. What do entertainment lawyers do regarding publishing agreements? Well, we write them, we review them. Typically, we're reviewing them because we work for writers. So a writer will come to us and say, hey, I've received this publishing agreement from a publisher. Can you look at it and tell me what the red flags are? And we'll look at the publishing agreement, we'll provide comments and have a discussion with the writer about, are these terms fair? What should you be concerned about? And is what you should go back to the publisher with. And then finally, we can do revisions on publishing agreements as well. So if we have the review, we've had a discussion with the writer about what needs to be done, and the writer says, you know what, I'd like you to make those changes in the contract and help me negotiate the contract with the publisher. We do that as well. And then we have a couple of tips. Always know the person that you're contracting with. The more you know about them, the better. You really want to be able to trust the person on the other side, and often contracts will contain representations that a party has the authority to enter into the contract, to grant the rights that they're granted, and promises about what they're going to do. And also, don't feel the need to agree to obligations beyond what's required to achieve the objective of the contract. Keep in mind, what's fair? What would it be fair for you to give up in this agreement to receive what you're getting? We've had a few questions come in, so maybe I will turn my mind to some of those.
So there's a good one here that says, would publishing a poem be considered consideration? The example here is that the writer gets a poem in an anthology but is not paid, whereas the publisher gets proceeds from sales of that anthology. So I think the question here is being published itself, could that be considered consideration?
Yeah, so it's a great question. I believe it's possible. Certainly, I've seen contracts where it just says, the privilege of appearing in this show, or the privilege of having my work published and disseminated and made public in this publication is consideration. Whether a court would agree with that is probably going to be determined on a case-by-case basis, but I've certainly seen it in contracts. It's not that common, because if you have the payment of $1, of a token amount, it's indisputable that consideration was received. So it doesn't really make sense to provide consideration in that form, in that type of intangible consideration, which isn't also supported with something tangible like a token payment. But yeah, I've certainly seen it. Yeah, and arguably it is consideration.
Yeah.
You know, the question is, did you actually receive something of value? Which is why, you know, it will hinge on a case-by-case basis. If the book is, you know, or the work is not published, or it's of no value to you, you know, if you were arguing that you were the writer and you're arguing that that wasn't valid consideration, you would say, hey, I didn't receive any benefit from this. You know, there was no way that being printed in that book benefited me.
So there's an added point here as well, that often in these agreements, a publisher will send copies, like at least one free copy of the publication to the writer.
Right, and so that's arguably consideration as well.
Yeah. And there's another question here. It says, when you publish with an academic type publisher, they don't pay you, but ask for the copyright. So I think the question here is just, is this a valid type of agreement? Is my understanding.
I'm a poet, creative writer, and independent scholar who is not on salary, publishes in the literary and academic publications. I've often had to handwrite what they can have and what they cannot have. Any advice on how to go about it and what kind of rights I have? So it is troubling to me that they would ask you to own the copyright because they're publishing your poems. Typically, in publishing agreements, publishers don't ask to own the copyright. They just have the right to publish and distribute the book. They don't take the copyright, ownership of the copyright. I'm surprised that the literary, you know, or the academic, that the academic publisher would ask for ownership of the copyright. If they're not paying you for it, I think that's a pretty raw deal. And you may have an argument that the copyright wasn't properly assigned, but enforcing that argument, you know, in a court is extremely expensive. You could proceed on the assumption that the assignment was invalid, but again, that's risky because if the university decides to enforce what it believes its rights to be, that could again, you know, engage you in a legal battle, which could be devastatingly expensive. And I mean, I don't think that's a fair deal. If they publish you, fine, that's great. But why would they own your copyright?
Yeah, there are they're not fully correlated, but there are instances where, you know, grad students at a university, the research that they do and the findings that they do for research, it'll all be accredited to the university. But I think this could be differentiated from that if you're fully transferring ownership of the copyright.
Right. So Marion Lougheed writes, generally when you publish in an anthology, you're not giving up any rights, merely granting a license. That I would agree with. I think that is a correct statement of what's typically happening. Yeah, well, I say I was surprised that the academic publication would be taking copyright.
Yeah.
Okay, and they provide you, okay, so it's typical to provide a copy of the anthology as payment. I mean, yeah, I think that's pretty, it's pretty hard to argue that that's not consideration.
All right, so we'll move on. Feel free to keep sending questions in, but
there was one question at the top by Anna Yin. If you get paid to translate others' work by the author or publisher, then published, your translation also applies to copyright as the author. Yeah, I do think arguably if you are a translator, you would have copyright in the translated version. When I've done contracts with translation services, you know, I always require that any right title or interest that's generated by the work of the translator is assigned to the original copyright holder. So the question is the translation a purely mechanical exercise? I really don't think it is. I think it requires judgment and skill, the exercise of judgment and skill, so that it would attract copyright protection. Now, if you put it into Google Translate, maybe that's a different story. But if you're doing it yourself, absolutely it requires the exercise of judgment and skill and would create copyright protection. And if you're having somebody translate your work, I would absolutely recommend getting an assignment of any copyright that they may generate. One more message. Okay. Okay, that's a comment from Daniela Elza regarding publishing in the academic world. And it's not a question, so it's in the chat, and you can all review it at your leisure. Okay, next slide, please. Okay, these are some common terms that you will see in most contracts, not all of them. So first one is the parties. That will usually appear right at the top of the contract, and the parties should be identified with sufficient clarity so that they can easily be identified at a later date if they need to be. Typically, when we're talking about an individual, we provide for an address, and we may a name and an address, and also not often, but not a bad idea to include some type of identification number like a driver's license number. Don't see that very often, but I think from a legal perspective, it's a sound practice. And for a corporation, you would typically provide the name, where they were incorporated, and their address of the registered office, and sometimes if it's not a corporation, if it's a sole proprietorship, you could include a business identification number. Okay, effective date and term. So the effective date of a contract is the date on which the terms of the contract are in effect. It is not always the same as the date on which the contract is signed. So let's say, for example, I hire you to write me some poetry for an anthology. And you've started writing this poetry 6 months before the contract, we start negotiations for the contract. But the idea is that you're going to, continue writing, 10 more poems after the contract is signed. But I want for the contract to capture all of that work, the work predating the contract and the work after. So I would make the effective date of the contract, the date that the contract has a legal effect, a date prior to when the work on the poetry began. So I would backdate it 6 months or so. Now, it should be clear when you're doing this, the contract should always sufficiently identify what the execution date is. That is the date that it's signed, and what the effective date is. And they're sometimes the same, but they're sometimes different. The term is the period during which the contract will be in effect. Some contracts are open-ended. They don't have an expiration date, but if it's something like, I'm hiring you to produce work for me over the next 6 months, well, then I say, I'm going to determine this contract is 6 months. Basically, when the term's over, the contract is over. And all the terms of the contract will end, except for those which are specifically identified as surviving any termination. Consideration we talked about, that's payment, the exchange of something of value. Has to be in the contract for it to be binding. Warranties, representations, and covenants. So often a contract will require one or both parties to make warranties, representations, and covenants. A warranty is a promise that something will be a certain way in the future. A representation is a statement that something is the way it is now. And a covenant is a promise to do or not do something in the future. So in a publishing contract, a representation and warranty might be the work is wholly original to the author. That's a representation. And the work will not infringe the copyright of any third party. That is a warranty. And then a covenant would be the writer will not engage in any contracts with any parties which may interfere with the publisher's rights under this agreement. That is a negative covenant. It's a promise not to do something. So we see those types of things. An indemnity is a promise to compensate somebody for their losses for certain specified reasons. Typically, an indemnity in a publishing contract will say the writer promises to defend and hold harmless the publisher against any losses from third-party claims for copyright infringement based on the writer's work. So basically that's saying if the publisher gets sued because the work of the writer infringes the copyright of some third party, the writer is going to be responsible for all of the publisher's damages and costs in relation to that third party lawsuit. And that's what an indemnity is. Typically you want an indemnity from both sides. You won't always get it if you are the party with the less negotiating power, as a writer would typically be in a publishing agreement, especially a writer who doesn't have much track record and is perhaps their first publishing agreement. But an indemnity from a publisher that a writer would want would be an indemnity against any losses as a result of the publisher's breach of the contract or any third-party lawsuits that result as the action, third-party lawsuits against the writer that result from the actions of the publisher. Termination is always something that you need to keep in mind in your contracts. It's something that gets overlooked, but it's perhaps, it's one of the most important clauses. You need to know how you're going to get out of the deal if it goes bad. So pay very close attention to how the contract may be terminated, either by you or the publisher. Dispute resolution. So a lot of contracts won't contain a dispute resolution clause, and you include a dispute resolution clause to determine what process the parties will follow in the event that there is a dispute over the contract. So arbitration is a common process that parties agree upon if they don't want to resolve their disputes through the court system. Dispute resolution clauses can also say the parties will, work in good faith to resolve their disagreement amicably, private conversations. Failing that, they will hire a mediator to try to resolve the issue. Failing that, they'll go to a binding arbitration. A lot of contracts don't have that. They just say that, any disputes will be resolved in, the courts of the province of Ontario. So that's really up to the parties to agree. If the agreement's silent, then silent on what the dispute resolution is, then technically it could be anywhere. So in our contracts, most of my contracts, unless the client requests arbitration, I provide that all the disputes will be held in the province of Ontario, and the parties irrevocably adjourn, which is a contract word that I've never heard anywhere else. ATTORN, adjourn to the exclusive jurisdiction of the courts of Ontario. And then we got some general provisions here. Confidentiality. You may be required to keep the terms of the contract confidential, as well as any information about the other party that you receive as a result of the contract. So, for example, if you are hired to work on a movie, and I'm going to the movie example here because I find it more apt, you may learn things about that movie that the producer really doesn't want the public to know. You could provide spoilers or leaks or something that would harm the value of the film. So often contracts will require you to keep confidential certain things you learn as a result of engaging in the contract. Governing law, a very important clause. It says what law will apply to the interpretation of the contract as well as any disputes. So if the law is silent on, or if the contract is silent on governing law, and somebody sues you in California, it would be the laws of California that apply to the contract. So it's always good to specify what law you want to apply. And, we are Ontario lawyers, and we provide that the law of Ontario will provide in virtually all the contracts that we draft. The entire agreement clause says that this contract represents the entire understanding of the agreement between the parties and supersedes all previous and contemporaneous negotiations and understandings with respect to the subject matter of the contract. This is to make sure that if the parties have had verbal discussions about the deal, if they've exchanged emails, any kind of correspondence or communications they've had prior to the date of the contract are in the past, and they are not the deals of the contract. The entire contract is found within this contract, and any of that stuff that happened previously, it doesn't apply. Independent legal advice is an important clause to include especially when there's a bargaining imbalance. Sometimes a sophisticated publisher will engage a first-time writer who doesn't want to hire a lawyer, and courts have found that those types of contracts can be unconscionable because of the imbalance of bargaining power. So you'll often find in contracts that both parties have obtained independent legal advice or have had the opportunity to obtain independent legal advice and waived their right to do so. So that's basically why that clause is in there. It is a clause to protect basically the party who is in a better negotiating position from being found that their contract was unfair and that the other party didn't understand what was going on.
So there was one question that came in that's relevant to your discussion that you just finished, and it's how does a dispute work across the border? Let's say it is a US or European publisher, what do we have to watch out for? So I think this kind of relates to your point on one, dispute resolution, obviously, as well as governing law. If you want to speak to that for a moment.
Yeah, sure. So, if you're entering into a contract with an American publisher, it's probably not great for you if the trial occurs in the United States. You'll have to travel there, probably. You'll have to hire foreign lawyers, and it is more of a headache for you. Now, it's probably not going to be a point on which you can negotiate. But yeah, the effect would be that the trial would occur in a different jurisdiction, and the laws that apply would be the laws of that jurisdiction. So basically, the contract it should define where disputes will be resolved and what laws will apply to disputes. And that will be the same, if you're contracting with an American or with a European or wherever. The contract should consider and define those things.
Yeah. And the two questions that came in before, we will get to them in just a moment. They may be answered, though, in the next couple slides. So moving on to a few examples of specific agreements that may be relevant to you. Firstly, there is the publishing agreement. So what exactly is a publishing agreement? Well, the context here is that a publisher has agreed to publish and distribute your work. And so the list of items here are types of clauses that will often arise or be found in publishing agreements. And in some cases, if you don't see these addressed in any way, that should be cause for concern. So firstly is the grant of rights. So this relates to intellectual property and ownership of the IP. So in this case, you're granting certain rights to the publisher in order to enable them to effectively publish and distribute your work. So there'll be the territory defined, and that's where the grant of rights extends to. Oftentimes you'll see the world and beyond the world, so pretty much just encompassing everything in any location the grant of rights will apply to. There's the term, so how long does this grant of rights exist for, and are they in effect for? And then what kinds of formats do these rights encompass? So is it books only? Could it be adaptations to film or to series? Does it encompass music? As well as the formats might go past that to things like prequels or sequels or spin-offs and anything like that. So it's encompassing all the rights that stem from that original work. And then there may be a clause pertaining to retained rights. So it might specify expressly what rights are retained by the writer, or in other cases, it may say any rights that are not identified in this contract are automatically retained by the writer. Then there might be another clause or section on the delivery of the manuscript or copy. So this is identifying in what format and when the delivery of that manuscript will be required to be sent to the publisher. There might also be some stipulations here about edits, so some clauses about edits that are required by the publisher and how that might be enacted by the writer, and the approval process, and so the back and forth with that to approve the manuscript. And then there's the publisher's obligations and writer's obligations. So again, the writer's obligations, they'll usually come down to like dealing with the manuscript, completing it, delivering it, completing any edits that are required, and then any other future roles or involvement that the writer might have. The publisher's obligations, on the other hand, they're not actually always found in the publishing agreements, but they should be. So their obligations are obviously to publish and distribute your work, but these agreements should really set out in what way this will be accomplished or attempted to be accomplished. So what exactly will the publisher be doing to try to publish your book, distribute it, and also monetize it? So that might include things like marketing and other items like that, but it really should set out some of their base obligations, because it will also help the writer be confident that their work will be published effectively and sell. Next is the advance. So this is a sum of money that will be paid to the writer. Sometimes there's a schedule involved with it, so it might be a certain percentage of the advance or a certain amount is paid, for example, upon the execution date. So when the publishing agreement is signed, further amount might be paid later on after, for example, the delivery of the manuscript. And then there may be another advance amount as well at a later date. However, it also all might be together at one specific date. And usually this advance is recoupable. So this is something that's important to know, that an advance, generally speaking, is not, it will be recouped by the publisher, which means that future earnings that go to the writer will write off the advance. So the writer will not continue earning until the advance has been recouped in full by the publisher. And so this leads to royalties, which is essentially back-end compensation. And so it may be that the writer earns a percentage of the sales perhaps in all formats of the publication. The percentage might also change depending on the format. So for example, an ebook might earn a different percentage than a paperback versus a hardcover versus an anthology, and so on. So the agreement should stipulate, if there are varying royalty amounts, what they are here. And again, that plays into advance. And then there's also net profits. So there should be a net profit definition that kind of specifies what percentage, where the percentage will come from that goes to the writer. So usually all of the upfront costs that the writer will have will be the earnings, the royalty earnings will be less those upfront direct costs that the publisher incurs. There's often also book returns, or something called monies held in reserve. And this is in anticipation of books that are returned by buyers. So often a publisher will hold back often is about 10% of the earnings that would be going to the writer. And that's in anticipation of monies that they have to pay back to buyers of the book who ultimately decide to return the book. And again, here it should be stipulated exactly when those monies held in reserve will be paid to the writer. So often it's 6 months in the future or 1 year in the future that those monies that are held back will thereafter be paid to the writer. There's usually also copies, so free copies that are sent to the writer from the publisher. This might be for the writer's own use, for their family or friends, as well as there might be a discount for further copies of the book that the writer would like to obtain. So it might be something like 40% of retail value that the writer can pay for further copies of the book. Then we get into discontinuance of publication. So what happens if the publisher stops publishing the book? Do the rights revert? What are the publisher's options there before there's a reversion of rights? And exactly just what occurs when and how when the publisher stops publishing the book. And so this kind of leads into the reversion of rights. And this is where all the rights that were granted to the publisher revert back to the writer. So usually these happen on set events, such as the discontinuance of publication or upon termination that we're getting to. And this is an important piece to kind of review and make sure that it's all okay, to ensure that as a writer, you'll be confident that there are instances where all of the rights will be granted back to you or will revert back to you. And then there's termination, which Ian kind of touched upon briefly, or I'm sorry, not briefly, but it is a really important clause and section of a publishing agreement. And that's just how, if any, how can you terminate the agreement and upon what circumstances, and what happens should either party terminate. Again, there may be a reversion of rights, there may be options here, there may be that if the advance hasn't been recouped in full, that the writer then has to pay the remainder of the advance to the publisher, and so on. And lastly, there's moral rights. So this is kind of a topic that can be kind of unto itself, that's quite important for any type of creative agreement. And moral rights are also quite unique in Canada, where they don't operate in the same way, or if at all, in the US. And generally speaking, moral rights are something that an author has as soon as they create a work. And so some of the aspects are the rights of attribution and rights of integrity. And so this is that the author will be accredited with their work. So that's attribution. And then the rights of integrity is that future uses of the work will not diminish or defame the value of that work. And oftentimes in any of these agreements, you'll have a waiving of their rights. So it'll be a mandatory clause where the author's actually waiving their moral rights. However, in most cases, you'll still get an alternate clause, like a credit clause, that will still give the author credit, even if their moral rights have been waived. And of note with moral rights, they always stick with the original author. So they do not transfer with ownership of copyright or anything like that. They're always with the original author. Anything to add there, Ian?
Yeah, just further on moral rights. They are inalienable to the author, which Michael said, so they cannot be assigned. They can't be given away, which is why contracts provide for a waiver, basically a promise that I'm not going to enforce them, but they can't be given away to anybody. They stick with the author, the creator, and like that goes back. Like the life of copyright is tied to the author, so too are moral rights.
And moral rights, again, they're actually found in the Copyright Act. Okay,
at this point, I think we can look at some of these questions. So Lisa Reynolds writes, scenario, if a poem is accepted without a contract, but is not published within 6 months, is there a timeline that the writer is bound to the publisher? So the short answer to the question is, if there's no contract, then you're not bound to anything. But I think what you mean in your question is if there's no written contract. If there's no written contract, then we need to do the analysis of whether a contract exists at all. And in this case, it's very unlikely that a contract exists. We do have an offer and an acceptance. The poem's accepted by the publisher, but what are the terms? Right now, you don't know like it's apparent from your question that the duration of the grant to the publisher is unknown by you. And if it's not, and that's an important term. So this situation would probably lack the certainty of terms required to form a binding legal agreement. And as I started by saying, if there's no contract, then there's no obligation.
There were a few added comments since then. Would an email of acceptance constitute a contract? So I think
It certainly can. It certainly can. But it's a bit of a complicated analysis because you need to consider the other factors of whether a contract exists. Is there a meeting of the minds? Is there intention of both parties to be legally bound? Is there consideration? And can the essential terms be ascertained? If all those elements are there, then yes, it would create a contract.
So even Ian's comment there might answer the question of the meeting of the minds. From the scenario itself, it sounds like there is not a meeting of the minds, where it seems to be the expectation of what's happening with this publication, that there's very different ideas of what's happening, where the writer here, it sounds like they're anticipating it something to be published in the near future, whereas there's no understanding on the other side. So, you know, even there, the haziness of the terms puts everything into question.
Thank you so much for all of your careful attention to these questions in the chat as well. I do want to note that it is about 3:15, so we have about 15 minutes left. I'm not sure if there's more left in your presentation or if we are solidly in questions territory now.
I think there's one more slide, and then we had an exercise at the end, which is discretionary if you want to go through it. Let's move on to the final slide. I see the one question is the right of first refusal clause. So that is typically a clause that a publisher will require if you are a writer and you're producing subsequent works. The publisher will say, we have a right of first refusal to be the publisher on all those works, which means you have to come to us with the work and we're allowed to publish it on terms that are the same as this initial agreement. It's a clause that's very beneficial to the publisher and not typically in the writer's interest, because it gives the publisher the option whether or not they're going to be the publisher. A better clause is a right of first negotiation, which says you have to go to the publisher, at which point you two will negotiate the possibility of a future agreement and perhaps reach an agreement that way, but you're not obligated to go with the publisher in that instance. Okay. I hope that addresses that one. Okay, and let's go to the last slide then. Is this it? Sorry. Okay, so my box was blocking the title of the slide. All right, option agreements. So an option agreement is an agreement that a writer will typically receive from the ones that I see are typically from television or film producers, where the television or film producer acquires the exclusive option to purchase the rights of the work. Now, they're not purchasing the rights, they are just paying for the option to purchase the rights. And typically they'll give themselves 2 to 5 years for them to undertake development work, to gauge appetite amongst distributors and financiers, to see if they actually want to make the movie or TV show. If they decide that they do want to proceed with making the TV show or movie, then they will do what's called exercise the option, at which point they will pay a purchase price and they will then acquire all the rights. So the typical terms, or some of the main terms you would see in an option agreement, are the grant of rights. What specific rights is the writer granting the producer? 1, during the option period, and 2, if the option is exercised. So during the option period, it's typically the right to create development materials based on the work and to create pitch materials to potential financiers, and then the rights granted upon the exercise of the option is typically a grant of all rights. And then the option period is the time during which the producer has the ability to exercise the option. Often there'll be an initial option period of 1 or 2 years, and then an additional option period, which requires a further fee, again, for a period of 1 or 2 years. The purchase price will be the price payable upon the exercise of the option. Exercising the option is the same thing, and extensions, we talked about that. That's the option period is extended. Contingent compensation is basically a share of net profits, which it's not guaranteed to be in the contract. They may just pay you a flat rate as a full buyout, or they may cut you in on the back end. Often writers will ask for continued involvement in the project. That is, if the production is made, they want to be hired as a producer, as a writer, or some kind of consultant. So if that is the case, then that should be negotiated at the outset. Further works, that's like the right of first refusal. It may not be it may not be the right of first refusal. The further works will typically say that the producer has the right to create all kinds of derivatives, prequels, sequels, spin-offs, etc., based on the original work. And the reversion of rights, typically there'll be 2 places where the rights will revert. One, if the option is not exercised during the option period, then all the rights will go back to the writer. And then what I always like to put in there, which is sometimes not in there, is that if the principal photography of the film doesn't start by a certain date, typically 5 years, or it could be 7 years after the exercise of the option, then the rights will revert. So if the producer is just sitting on the rights and doing nothing with them, we want those rights to return to the writer, and that will, one, it will get the right of the rights back if nothing's happening, and 2, it will provide some motivation to the producer to do something with the property, otherwise they're going to lose it. And dispute resolution, we already talked about. Okay, so there's another question. A specific question about right of first refusal was in the case of a writer who has written more than 1 subsequent book to that published. Is there a question there, or is that a comment? Okay.
Does the contract only refer to the first book in sequential order, say written after that contract for the previous book?
Right, thank you. Typically not. Typically the contract would refer to all the subsequent works, but it really depends on what the contract says, and it very well may specify it's only for the next subsequent work. It really depends on the wording of the clause, but when I see these clauses, it typically applies to all subsequent works.
Okay, thanks.
Welcome. Do we have time to do the exercise? We got 10 minutes. Michael, you want to lead this?
I think we can just open up the floor to see if anyone else has questions. So we're not rushing it then. If there's any leftover material or questions that people had, we can send these PowerPoint slides to to Nick though, and they can kind of distribute them to anyone who would like to get a copy. And as well, if we're always available for further questions and conversation, our email and our other sites and ways of contacting us or finding us are all on the side here. So again, we're always available if there's anything remaining after today. But for now, we'll, yeah, if anyone has any remaining questions, we'll be here for a few more minutes.
Thank you so much again for approaching us. And I know our members, I know all writers, just it's so hard to wrap your head around these concepts. And it's really nice to get a refresher course from experts every now and then. So we really appreciate you coming and doing this for us.